All right, let's get you perfectly prepped for that midterm essay. If you've spent the whole semester focusing purely on offenders and the law enforcement side of things, well, today we're completely flipping the script. We are going to look at the criminal justice system entirely through the lens of the victim. Here's our roadmap for this explainer. We're running through early victimology, the just world hypothesis, blaming versus precipitation, routine activities theory, victims' rights and system trauma, and then we'll wrap up with the exact essay themes you need to know.
Let's start right off with Section 1, Early Victimology and How It All Began.
You know, it's actually wild to think about, but historically, early theories totally ignored victims. The system cared only about the offender's motives and actions. The victim, they were basically treated as just a passive piece of evidence. The logic was seriously cold. If you couldn't provide a solid description of the attacker or, say, physical or biological evidence, you just weren't considered helpful. You were essentially cut out of the whole court process. And that massive, glaring gap is exactly why the field of victimology was born. It was driven by this sheer frustration victims felt when their voices were just silenced in their own cases. When national surveys finally started asking people, hey, why didn't you report this crime? The answer was almost always this deep frustration with the system that ignored them. So victimology steps in to put the victim right at the center of the academic conversation. Moving right along into the psychology of how society reacts, we hit Section 2, the just world hypothesis and victim blaming. I want you to really think about this quote. If I do everything right, I am safe. This captures the just world hypothesis perfectly. It's basically a societal defense mechanism. We have this deep psychological need to believe people get what they deserve, right? Because if we admit that crime is totally random and that a lightning bolt of victimization can strike someone who did everything perfectly, well, that is terrifying. Believing the world is just keeps that panic at bay. So here's the catch. While this mindset definitely gives observers a nice, warm sense of peace, it actively creates subtle, deeply damaging victim blaming. We decide the victim simply must have done something wrong to draw the crime to them. By doing that, we make ourselves feel completely different from that person. We tell ourselves, as long as I don't do what they did, I'm safe. It diffuses our anxiety, sure, but it totally invalidates the victim. Okay, pay super close attention to Section 3, blaming versus precipitation. Confusing these two is a classic trap on essay exams. Seriously, do not mix these two up. Victim blaming assigns the actual fault and the moral responsibility to the victim. It's derogatory and it's short-sighted. Victim precipitation, on the other hand, is a strict academic study. It scientifically looks at the variables of risk in a situation to understand crime prevention. But, and this is absolutely crucial, it keeps all moral and legal fault exactly where it belongs, 100% on the offender. If you need a really solid, safe example to use in your essay, go with this unlocked car scenario. Say you leave your cell phone sitting on the dash of an unlocked car, and it gets stolen. Victim blaming points at the driver and says, you're an idiot, it's your own fault. Victim precipitation simply notes that leaving the door unlocked with a valuable item visible increased the variable of risk. The thief is still entirely the one at fault, but identifying those variables helps us figure out preventative tactics. All right, let's jump to our next major framework, Section 4, Routine Activities Theory. Routine activities theory argues that a crime only happens when three very specific conditions intersect in everyday time and space. First, you need a motivated offender, and the theory basically assumes there's always someone willing to break the law if the threshold is right. Second, they have to cross paths with a suitable victim or target. And third, crucially, there has to be an absence of a capable guardian to stop them. You literally need all three. Now, to totally nail this theory in practice on your exam, bring up campus blue lights. By putting these emergency lights all over a university campus, you are directly changing the environment. You're actively increasing capable guardianship, which then effectively decreases the presence of vulnerable, suitable victims. It's the perfect environmental deterrent for a motivated offender. For the second half of this explainer, we're shifting gears into Section 5, Rights and System Trauma. The historical timeline of events is your real evidence here. It shows how we dragged a system that historically mistreated victims into actually establishing a legal framework for them. It started with a massive grassroots movement back in the 70s, which led to the 1982 Victim and Witness Protection Act, and eventually the Crime Victims' Rights Act in 2004. These were massive steps, finally giving victims legal rights to be informed about their cases, to be present, and to actually be heard in court. Yet, despite all those hard-won rights, we still see massive underreporting of personal and property crimes. Why? Well, victims often hesitate because of embarrassment, fear of retaliation, or they just honestly believe the police won't do anything about it. But the absolute most critical vocabulary term for your exam is that final reason, secondary victimization.
Secondary victimization explains that profound frustration when the very system designed to help a victim ends up causing more harm. Imagine cases of sexual assault or domestic violence. The victim has to go through highly intrusive investigations, or they're put on the stand and aggressively cross-examined in an open courtroom full of strangers. It literally makes them feel like they are the ones on trial. It's a deeply traumatic re-victimization by the system itself.
A really tragic, real-world example from your text about this kind of systemic trauma is the crisis of missing and murdered indigenous women. The source material points out how historically institutionalized violence by governments, forced assimilation, and just staggering rates of femicide demonstrate a profound failure of the justice system to protect these specific victims. It's a stark, heartbreaking illustration of how massive systemic blind spots leave entire communities incredibly vulnerable.
Okay, we've got the pieces. Let's pull it all together in Section 6, Essay Exam Themes.
You absolutely need to memorize these 3 conceptual buckets for your test. First, be ready to explain the academic evolution from derogatory victim blaming to the scientific study of victim precipitation. Second, practice applying routine activities theory to a real-world scenario. Again, the campus blue lights are a great go-to. And third, this is a huge one, discuss the delicate balancing act our courts face. How do we ensure a victim's voice is heard without violating the defendant's constitutional right to due process and the presumption of innocence? Push too far one way and the other side's rights get violated.
I'm going to leave you with this provocative thought to chew on for your exam. We know that prosecutors represent the state, right? Not the individual. So if you were the one harmed, what would true justice actually look like to you? Would it be a harsh prison sentence for the offender? Or would it be having your voice heard, your questions finally answered, and your trauma acknowledged? Keep that exact perspective in mind as you sit down to write those essays. Good luck.